Will XRP be able to return the $1 price? How will the trial end? Can Ripple beat the SEC? We will answer these questions in today's video. Formerly, it was reported that attorney John E. Deaton said the sole success the United States Securities and Exchange Commission will likely claim in its lawsuit against Ripple is that the blockchain payments firm offered XRP as Ether as a securities from 2013 to 2017. The attorney, who is representing over 75,000 XRP investors as a friend of the court in the dispute, provided further detail about his assertions in a long Twitter thread yesterday. The market regulator does not perform a special how-we analysis by identifying transactions that constituted securities offers, as explained by Deaton in the discussion. Instead, he claims the market regulator is making the case that all XRP sales are in fact securities by using what he calls the but for test. The SEC's argument, according to Deaton, is that all XRP represents securities regardless of the circumstances of the transaction, since Ripple helped establish a secondary market for XRP. The SEC's assertion in its summary judgment motion is the basis for the attorney's opinion. The SEC argued that the investment of money prong of the Howey test was met because defendants did not deny that they offered and sold XRP in return for money, meaning fiat currency. To paraphrase the court's opinion, defendants' assertions and actions as to XRP establish the other components of the Howey test as a matter of law. The but for test, as a reminder, is used to establish fault in tort and criminal proceedings by showing that a certain result is the direct consequence of the defendant's actions and would not have occurred under alternative circumstances. In addition, Deaton notes that the SEC avoids doing a full Howey analysis by placing too much emphasis on the XRP coin. The market regulator's contention that XRP is symbolic of both the investment contract and the joint venture is shown by the lawyer. The attorney objects, explaining that this is not how Howey is implemented, as it is the particulars of the transaction that often decide whether or not an offering constitutes an investment contract. Remember that Deaton has stressed that an investment contract's underlying asset cannot, in and of itself, constitute a security. Apparently, the lawyer was able to persuade the court to agree with him in the Lowbury case, resulting in a formal admission of this fact by the SEC. A good Howey analysis led by the conditions of the sale would limit things down to particular transactions, not all XRP sales, as it now claims, and the attorney feels that the SEC might have had an easy and winning case if it had done so. Deaton wrote in the thread, "This is why I said the SEC may have snatched defeat from the jaws of victory," after disclosing that he has pointed out to Judge Annalisa Torres that the SEC's claims in the Ripple case are potentially the broadest and farthest-reaching claims the regulator has made in any enforcement action. As the papers in the case have been filed and the parties are now waiting for a verdict, discussions have naturally turned to the various outcomes. Deaton has said that he anticipates a trial by jury. When Brad Garlinghouse joined Ripple Labs in 2015, he certainly didn't expect to be at the center of one of cryptocurrency's greatest legal disputes. Garlinghouse has extensive company experience and fights regulators. Garlinghouse attributes his work ethic and honesty and responsibility to his Midwest heritage. Can Ripple's CEO fight for blockchain's future after working at some of the internet's top companies? Who leads Ripple Labs against the SEC with Chris Larson? We must go back to comprehend Garlinghouse's crypto market ambitions. Charles Hoskinson and Gavin Wood are computer science, trained blockchain leaders. The XRP founder comes from a business and economics background, not New York or San Francisco. Hutchinson, Kansas, reared Brad Garlinghouse. Garlinghouse was raised in a tiny Midwest town and values family and community. Wichita Southeast High School and the University of Kansas gave him a BA in economics in 1994. Garlinghouse completed his MBA at Harvard Business School in 1999 with bigger goals. Garlinghouse interned at Allen Company, an investment banking company, while college. Garlinghouse worked as a JP Morgan analyst for 6 years after graduating from Harvard Business School. These years exposed Garlinghouse to Wall Street and the World Economic Forum. Early internet giant Yahoo hired Brad Garlinghouse. Garlinghouse developed Yahoo Mail as Senior Vice President of Communications and Communications and Community. These platforms are the foundation of the current internet. Garlinghouse is most known for the Peanut Butter Manifesto after his contributions to Yahoo. This famous memo called on Yahoo to simplify processes. Fintech companies shared the message. In 2009, Garlinghouse became president of consumer apps at AOL. He developed AO Mail and instant messaging in this capacity. Garlinghouse also ran AO Ventures. Bebo's purchase presented fresh issues. AO Ventures sold Bebo 2 years later at a fraction of their acquisition price, making this move a failure. Brad Garlinghouse left Silver Lake Partners to work on blockchain and digital assets. Garlinghouse identified Dell MC, Airbnb, and Alibaba Group investment prospects as managing director. Garlinghouse was also a senior exec at Hightail. Garlinghouse made sure Hightail kept offering creative productivity solutions to its global customers after rebranding from Usendit. Garlinghouse left corporate life to join Chris Larson at Ripple Labs in 2015. Since then, Ripple's CEO has led its growth in XRP development. Garlinghouse has advocated using blockchain to address banking regulations and cybersecurity. His outspokenness has made him a target of the SEC's cryptocurrency assault. The SEC's lawsuit against Ripple Labs has tarnished the blockchain company's CEO. The complaint seeks to clarify how the SEC regulates XRP. Brad Garlinghouse and Ripple Labs call XRP a currency, whereas the SEC calls it a securities. Ripple Labs and XRP have suffered from the litigation, with Coinbase removing the coin. Fear, uncertainty, and doubt have clouded XRP's prospects in previous bull markets due to reduced trading liquidity. The lawsuit should be resolved by mid-2023. The SEC's crypto and blockchain crackdowns continue. The SEC penalized Kraken $30 in February 2023 for their staking offering. There has been considerable activity surrounding the sealed papers considered vital in arriving at the ultimate verdict in the current court action between Ripple and the United States Securities and Exchange Commission, SEC. Specifically, on February 16th, defense attorney James Phelan tweeted that media personality and Forbes senior writer Rosalind Layton had filed a petition to acquire the confidential Hyman speech record. According to the petition filed by Rosalind, the First Amendment and federal common law provide a strong presumption that the press and public have access to court papers. The petition claims that holding the court responsible requires using this particular privilege. In addition, Layton claims that the SEC has been inconsistent in its oversight of cryptocurrencies, arguing that the agency has yet to provide definitive standards for the regulation of the industry. Given the SEC's refusal to provide explicit regulatory guidance on cryptocurrencies, Layton claims that immense significance has translated into intense public scrutiny of Hyman's speech, which is the only instruction anyone within the SEC has offered crypto stakeholders to avoid the wrong end of an enforcement action. Carl Sekir, the proprietor of Sekir PCE, a legal firm specializing in Supreme Court and appellate work, likewise concurred with the motion. We recently filed this application for permission to intervene in the SEC's UV. Ripple lawsuit seeking billions in penalties from Ripple based on their cryptocurrency XRP, which the SEC argues is an unregistered securities, Sekir said. Curiously, minutes after the motion was filed, Forbes mysteriously pulled an article by Layton that provided a critical analysis of the apparent unjust handling of Ripple by the SEC. Ripple's argument hinges on the Hinman speech, given by William Hyman, the SEC's then director of the Division of Corporate Finance, in June 2018. The speech is widely seen as containing the SEC's view on whether or not cryptocurrencies should be classified as securities. Throughout this hearing, Ripple's attorneys have been asking the judge to force the SEC to hand over the relevant records for examination. According to the company's interpretation of the Hinman speech, XRP would be treated similarly to Bitcoin, etc., and Ethereum, ETH, both of which were designated non-securities. As insiders inside the SEC did not comprehend the instructions, Layton said that public access would thus be vital in allowing the public to judge the soundness of Ripple's fare. Notice argument. The SEC has specifically charged Ripple with operating unregistered securities offers through the XRP token sale. There's been much curiosity about the possible conclusion since some legal experts have questioned the SEC's categorization of securities. In this piece, attorney John Deaton for XRP holders argues that the agency may lose the summary judgment because of the uncertainty surrounding the proper designation of XRP as a security. Deaton, responding to Layton's most recent filing, said the information contained inside will be made public in due time. This is exactly what I was talking about when I predicted that the leak of the Hinman emails would prevent any chance of a settlement. You put the genie back in the bottle, he said. While waiting for the final verdict, SEC has also requested that other records pertaining to expert witnesses be kept under seal. The crypto community as a whole has been critical of the move, prompting Ripple to take action in opposition.